The writ petition is allowed and the impugn order dated 23/1/2026 is quashed and the order dated 22/12/2025 is restored.
May I please, your lordships? Lordships, I understand the difficulties of the court, but then I have three urgent writ appeals. All are analogous. It's a issue involved is short. I filed it on the 21st, but the matter is not listed. So I may be allowed to move those writ
Subject to availability of time, because the one of us will be here only till 1 o'clock.
Lordship.
Okay.
Applies.
Please, your lordships, kindly allow me to move and unlist the item. Habeas corpus matter now.
Okay, subject to availability of time, because at 1 o'clock I'll have to leave.
Obliged, madam.
Perhaps your lordships. Lordships, I would like to mention item number 28 and 29 in the hearing list, lordships, part 2.
Yes.
Lordship, there's a similar matter writ petition, and the matter is listed tomorrow, lordship, with regard to the limited departmental exam on Tuesday. And somehow these two matters are linked with that writ petition also, lordship. So may I pray that if, with the indulgence of the court, lordship, if the matter can be listed on Monday, it's true, because it will have some, with the permission of the court, lordship. It's a very short matter, lordship. It's a very short matter.
No, but bench has to be constituted then.
On Wednesdays, yes.
This way.
If the lordship permits, lordship.
On Monday.
On Monday, lordship.
It can't wait till Wednesday.
Lordship, because the single bench matter is coming up on Tuesday. And the limited departmental exam is going to be conducted on 6. So Lordship has given a short date notice on the writ petition 56.
Okay.
With the indulgence of the court, lordship.
Okay, then Monday. Both sides are represented on the prayer made by Mr. N. Moswil and it counsel for the appellant.
Appellants, lordship.
The matter stands adjourned today. Next matter, he expresses some urgency in the matter. Accordingly, let the matter be listed
On 4th, lordship.
on 4/5/2026 at how much time it will take?
Lordship, it will not take not more than half an hour, lordship. This is a short matter, lordship.
3:30 p.m. 3:30.
Lordship.
Because the single bench is there on that day.
Lordship. I'm deeply obliged, lordship.
May this lordship, I beg to mention item number 32.
22.
32.
32. Yes.
Lordship, here in this matter, AG is leading the case. So I pray that 2 weeks' time may be granted to us to file our affidavit. And
You have
the
not
mat-
yet filed your affidavit.
Yes. And the matter may be listed on 17th of June, Lordship.
No, but do you assure us that you will file your affidavit by then, by 2 weeks?
Yes, yes, Lordship.
Okay. All sides are represented. On the prayer made by Ms. V. Sukori, Learned Additional Advocate General, 2 weeks' time as a last chance is granted to the state respondents to file their affidavit in opposition in the matter. Next paragraph. It is submitted that in this case, she would be led by the Advocate General and accordingly placed for a fixed date of hearing. Next paragraph. As prayed for, list on
17th of June.
76/2026. Okay.
Much blood.
I beg to mention item number 30.
16,
30.
13.
Hearing item 30. Can it be listed next week, my lord?
13 you'll have to wait because it's a link matter. If this is adjourned, then all cases will fall.
No, 30.
30,
Not
30.
30.
30.
30.
Oh, acha, 13 I thought. Okay, you are for? You are appealing for?
Petitioner lordship. Appellant.
Okay. Both sides are represented on the prayer made by the counsel for the appellant. Matter stands adjourned today. List,
Next week, my lord.
list, next week would be 6th. Okay.
There is an interim, my lord.
Okay, interim order passed list stands extended till the next date of listing.
Much.
God bless.
May it please your lordship, I beg to mention item number 31. Here, your lordship, I have sought for certain clarifications which I'm yet to receive. So if this matter can come up after 2 weeks.
You want to do what?
Your lordship, the last occasion I was directed to get instructions from the department. I received instructions, but certain clarifications is required there. So 2 weeks may be granted, your lordship.
You have not filed your affidavit.
No, your lordship, just instructions.
Which department is that?
PWD, your lordship.
Which is represented on the prayer made by Learned Government Advocate. 2 weeks' time is granted to obtain appropriate instructions and to file affidavit in opposition. Next paragraph. The Learned Government Advocate shall send a downloaded copy of this order to the PWD authorities to bring the order to the notice of the said authorities. List on, give a date after 2 weeks.
Much.
But this time send the copy of the order there.
May it please your lordship, I beg to mention item number 7.
7.
Yes. I pray that the matter may come up after 4 weeks.
I have no objections, my lord.
Okay.
Full matter.
But this is 2017 matter.
Yes, Lordship, this is an appeal against acquittal. Right.
And the appellant is the victim or the next, what do you call the next?
Yes, my lord, my lord.
No, then it's not appreciated. 2017, we can't adjourn.
Lordship, after 3 weeks, Lordship.
2017 is 9 years. For an appeal to be taken up, the matter would become infructuous by afflux of time. After 9 years, even if we want to convict, we will not be able to.
And 9 years after acquittal. Next week.
Yes,
It can be taken up on 6th, lordship.
Next week,
If it
my
can be
lord.
next week.
Next Wednesday.
okay. both sides are represented. The learned counsel for the learned instructing counsel for the appellant prays for an adjournment. First of all, this is an appeal of 2017. The adjournment is reluctantly allowed. Next, the matter would not be adjourned on the next date of listing. Next, list on the same 6th. Okay.
Lordship, item 8.
8.
Yes, Lordship, it may kindly be closed. It has now become infructuous.
On what ground?
The appellant, he has, on remission, he has completed his
The sentence is over.
Yes, my lord. He has already been released. I have been informed by the jailer yesterday.
How many years?
10 years. So he has served less than 10 years, Lordship.
Appeal was filed late. Appeal is 2020.
Yes, Lordship.
5 years after the conviction.
Yes, Lordship. Since his initial arrest, he was never enlarged on bail. It's a 376 case. Bail was also recently allowed. However, when we went to execute the bail application order, he was already
Just
You set up in the community 2017 or was it? 17 and 17.
The investigation was completed. So I will set off.
he has completed 10 years, including of
Yes.
set off.
yes,
All this.
yes,
Taking account the
Yes,
set offs.
He was arrested during investigation and never released from.
yes, Lordship. During the trial also, he was never enlarged on bail.
Okay.
Recently, the sentence was suspended, but when we went to execute the suspension order, he was already released from jail.
Okay. Upon instructions, Mr. Your name?
Santiago, my lord.
Mr. Santiago, learned counsel for the appellant,
Yes, my lord.
submits that
Legal aid counsel,
Legal
my
aid.
lord.
also legal aid counsel has submitted that he just give the other file, IA.
He's on bail now. He's on.
No, Lordship.
He was
When we went to execute the bail order, his sentence was already completed and he had already been released. Yes, Lordship. Sentence was
No, it's okay.
suspended only recently
That's okay.
by the last division bench.
What are infractions?
The Learned Legal Aid Council has submitted that this court by order dated 8/4/2026 passed in bail application 1 of 2020 in connection with the instant appeal, had granted bail to the appellant. However, when steps was taken to have the appellant released on bail, he was informed that during the pendency of this appeal, by taking into account the set off of sentence, comma, the appellant has already been released on completion of sentence or on serving out of the sentence. So accordingly, comma, he has submitted that the matter has become infructuous. Conviction আছে conviction obviously তো other fight করতে পারে নিবা পারে আচ্ছা but Mr. Santiago, you see
Lordship.
he may have been acquitted sorry released
Yes, Lordship.
but he was not acquitted.
Yes.
The appeal can still be taken up for hearing because the sentence, if it is there, conviction and sentence,
Yes, Lordship.
it may be adversely affecting him. So please take instructions whether he wants to withdraw it.
Lordship. Lordship.
You see, if he can still fight for his acquittal,
Lordship.
notwithstanding that he's served out his sentence.
Yes, Lordship, that in that case, Lordship, if you can kindly be listed after 3 weeks, Lordship. In the meantime, I'll seek instructions from you.
Okay.
I am informed that he is working in one of the auto workshops in Gauhati district.
Okay.
Because
Then-
conviction is a taint, right? So a person may like to fight, try to wash that taint also.
My lord,
Don't say it is a process. It's been released. Next paragraph. Accordingly, if praise for and is granted 3 weeks' time to obtain instructions as to whether the appellant is still willing to pursue the instant appeal. First of all, matter stands adjourned today. List after 3 weeks.
But if your voice, alerts, informed, and kiss for it, respond to. And we kiss for respond to.
Oh, sir, I'm sorry. Mr. P. Patel and legal aid counsel for respondent number 2 is present.
No.
Okay, I'm sorry. And who is the APP? We'll have to record his presence. You are there? Okay, please record his presence also.
But Lordship, in item 9, if the matter can kindly be refixed on 13th of May, my lord. The senior SPP, he wants to appear in the matter, is from Gauhati, so we expect for fixing the matter on 13th of May.
Okay. Both sides are represented on the prayer made by Mr. Santiago and a special PP for the NIA. The matter stands adjourned today. List on 21, 13, 13/5/2026.
Files adjournment request. If this matter may be taken off 3 weeks, have some difficulties of it.
Okay, this is appeal by the state against acquittal.
Yes.
Okay, which is a
Jail.
right. Can't we say just you see the file? Let us see the file. Item 10. No, take jail.
Must be a mistake. No. Just written jail appeal. Yes.
Why this is written as jail appeal?
Must be error.
Yes, this is in jail.
Huh?
He's in jail.
They will give this, we have 302 and that will give, and will be 304.
Oh, I see. You are appealing against that.
Yes, yes.
I see. Has he filed any appeal from jail?
It will be jail appeal.
It won't be jail appeal from the, but he may have preferred, has he preferred any appeal from his side against the 304 conviction?
No,
That
convict
will be
is
jail appeal.
responded here. It has to be re-registered as, this will not be a jail appeal. This will.
State as against the 304 but he may have preferred an appeal against the 304 conviction as sentence.
Jail appeal, no.
It was jail appeal over. It will not. Pre-registered.
Your procedure under 383 follows if it is a jail appeal in CRPC. This will not be jail appeal, it will be re-registered as a regular appeal. Both sides are represented on the prayer made by Mr. Kiangami, Learned APP. The matter stands adjourned today. Next para. This being an appeal filed by the state against acquittal of the respondent for offences committed under section 302 IPC. Full stop. Thus, the registration will examine as to whether the registration of this appeal as a jail appeal is appropriate, and if not, the appeal may be re-registered as a regular appeal. Next, let the order be brought to the notice of the registry. Next, list on 3 weeks. Okay, so it may be re-registered. You just keep a track. Actually, please record what is the presence for the informant, respondent.
Like this. Respondent.
Respondent.
It's the lowest matters 11 to 25
Yes.
from the hearing list. If you can currently fix on 20. I have taken the counsel of the 20. I have taken the counsel of the.
You have further respond?
Just give this file item 12 or some. Nobody is appearing in this item 12.
I was supposed to agree that I become 20 to 23 may be segregated from this case.
I have no objections to this is the level.
No, I have a question is different. You see, in item number 11, somebody is appearing for the respondents.
Yes, Lordship.
But in other appeals, none of the names are reflected as appearing for the respondent. So whether the service is complete. No, state appeal by respondent.
I'm for item number 20.
Yes, I just made it to Lordship and I pray for the stamp Lordship.
You see, please come and cause this come by one. Item 12. Who is appearing for the respondent?
Yes, Lordship.
Is ये file your वकालतनामा. ये file your वकालतनामा. 11 to 91. Next item 12. No, your presence is not recorded here. If you have filed, then we'll record your presence because your presence is not recorded in these appeals. No. Please try to understand that's not the query. Have you filed the wakalatnama? That is the query. If you have not, because then there will be a it will be a default on your part. We may not hear you without your wakalatnama. No, please do it because otherwise you will be in default. We may not give you an opportunity of audience once your wakalatnama is not there. Correct. In item 16, you see both sides are represented on the prayer made by learned government advocate. The matter stands adjourned today. List on after.
What's up 20? 25.
20.
Yes, my lord.
Okay, 20 May 2025.
Items 20 to 23, the time is segregated.
Just a moment, we'll come to that. In item number 12 to
My lord, the item number 11 to 19. These are all of them. My lord.
we are not passing analogous order. That's the difficulty. Respondent's presence is not even there. We'll pass separate orders. You see, otherwise there will be difficulty. They are not present in other cases. Then in item 12 to 19, please pass separate orders in each case. Here you say, on the prayer made by the government advocate, the matter stands adjourned today. Your name? Learned Counsel submits that she has entered appearance in WA 16 of 2022 and is instructed to appear in all these matters. Next para, if that be so, comma, the Learned Counsel intending to appear for the respondent shall file her wakalatnama in the meantime. Next para, list on same date.
My lord, that the matter will stop. It should be.
Same, 20. We are picking on same day. Now, item 20 to 23. Want this to be segregated.
Yes.
It's not linked with the other matters.
No, it's actually that.
Okay. Then item 20 to 23, please pass separate orders. Say both sides are represented. The learned government advocate submits that this matter is the issue involved in this writ appeal is not connected with the issue involved in WA 16 of 2022. Accordingly, this, in view of the consensus at the bar, this item is segregated from the bunch of appeals with WA 16 of 2022 and shall be listed separately. List after 13/5/2026.
My lord, 230.
If you're segregating, then it can't come together.
My lord, then, the 27th, my lord, because of the same, I also being was there.
27th is a holiday. You want to be heard on that day?
Then motion by very completely.
No, because I also follow another principle.
Yes.
Walls have ears. You can come here, argue before the walls, and we'll take care of it.
Well, 3rd June, what's it? 3rd June.
3rd June.
The motion, if that is the least, maybe the 20. 20.
Since the other matters are.
Yeah, since it is segregated, don't you think, madam, it will be better on a different date?
Lordship, this will be the leading case. This will be the leading case.
Then why you are segregating it? I don't get it. If this is to be heard along with 16, then why you are segregating it?
Issue is same.
Because one of the judges, they took up, they passed the early judgment because of which we could not take up this case. I think there is a big issues.
Issue is same. Then we are not segregating it. It creates difficulties. You see, we are hearing in a batch of 4 cases 1 and in 6 cases 1, we will be confused.
Yes, Lord.
If you segregate, it will come different bench. It may happen that it may come to a different bench. So then don't segregate it then. Don't pass that order. You just say adjourn list on 20.
My lord. Oblige, my lord.
Mr. Huri, I think you can understand, because we will not be able to take two different notes for 2 different batches of writ petition, and then if the issue is same, we'll be confused.
So my view is that worship, if this one is allowed, the people cover the other cases.
Then there's no issue of segregation. Storage capacity is very nil.
For motion from the supplementary cost list, item numbers 33 and 34.
There's a delay.
Yes, some then 1,309 peaceful.
What is the good reason to have so much of delay?
Well, I'm serving as a valid and the matter was supposed to be on 24th of June 2025. And well, took some time for doesn't come to also to prepare for the agreement. And since the permit is in that district, in subject district, there's been some before this, so took some time to also get significant statements.
Notice. Who is appearing for the state? Who's the APP appearing for the state?
Informants.
You'll be there? Okay. In the meantime, we are issuing notice to the informant and the complainant. Okay. Heard Mr. T.O. Longkumar, learned legal aid counsel appearing for the applicant. Also heard Mr. I'm sorry, I forgot the names. Learned, your APP, PP, learned public prosecutor appearing for the state responder number 1. Next para. By filing this interlocutory application under Section 5 of the Limitation Act, the applicant, who is the appellant in the connected appeal from connected jail appeal
16/6/22.
has prayed for condoning the delay of 1,339 days beyond the period of limitation in filing the connected appeal. Next para, the learned counsel for the applicant has submitted that as legal aid counsel, he has been recently given the brief, and by the time substantial delay had already occurred. Next para, be that as it may, issue notice returnable on, give a fixed date after 4 weeks. Make it 3/6/2026. The Learned Legal Aid Council shall take steps for service of notice on the respondent number 2 and 3 by filing the requisites before the registry. Next para. The registry on receipt of the requisites from the Learned Legal Aid Council shall hand it over to the Office of the Public Prosecutor, Nagaland, for onward service of the notice to the respondent number 2 and 3 through the jurisdictional police station. Next para. The officer in charge of the Shobha, CHOZUBA, Shobha Police Station, shall ensure that the service report is returned prior to the next date of listing. Next para, list on 3/6/2026.
For admission, item number 1.
Also, considering idea to respond from the first. Because I have taken the consent from all the parties. Also, I got this letter of 15th day.
Just a moment.
Require paper book.
one of the court and directors to protect the illegal has already been made, and therefore we work off. On the next thing we will do. Because there are some certain discrepancies
Okay,
where they have shown that they have paid,
okay.
but actually the money has not reached me.
The beneficiaries.
Yes. Around 2,000 plus claims. Must not be the money of not covered. And other hospital.
So by the time the respondent four will
Yeah, it will be.
place it on the call.
With our inform my department, say company. That way, yes, it was moved into this.
Can you can you request the section to have it in two files because it has become too bulky. Yeah, because the read petition is come down on this as. No, do it. Please give it a slip of paper, your names will record it. So and so are present for the respective parties. It has been submitted by orders passed by this court, comma, inquiry was ordered to be made. Just hear the order if.
Yes.
It has been submitted that that by virtue of orders passed by this court, comma, the respondent number 4 was ordered to make an inquiry as to whether the beneficiaries have received their respective claims.
No, the antennas.
Huh?
The antenna one.
So whether the empaneled hospitals have received their same amount. Most of it is submitted that some time is required to compile the information and to produce before the court. Next para, accordingly, Mr. N. Boswell, learned, standing counsel for the health department. You are appearing as a health department, standing counsel for the health department. Huh? So, Health Protection Society. Place for an is granted time to. It's okay. We'll produce the same on the next date of listing. Next para list on 13 May 2026.
For admission, item number 2.
May it please your lordship. Lordship, I appear on behalf of the appellants in this case, your lordship. Lordship, the engaged counsel, Mr. S.P. Sharma, is in bereavement due to the recent demise of his father, your lordship. So, your lordship, moreover, they have filed the objection to the delay condonation yesterday, your lordship. So, we're seeking 20th May for completion of the pleadings in the IAM.
You have filed your objection, no?
The respondents have filed yesterday, your lordship.
Okay.
It's a matter. When the appeal is not filed with a delay of around 835 days. That's the case. And the problem is not that because there are arbitrary proceedings going on between the parties. In June 2023, because
I don't think we are hearing it. You see.
Not hearing. It's not hearing. But just consider my difficulty. What is happening? I guess I was a bereavement. I cannot object much. That's very serious. But the problem is this. There are arbitrary proceedings that are going on between the parties. And it is filed by the claimant. The claimant is appellant. It's a private party and a PSU and the The contract which was granted to them was terminated by me in March 2023. They challenged it by way of a petition for the responsible writ for problem. The writ was dismissed on 23rd of June 2023. This appeal was not filed. It is filed only in November 2025 with delay of 800 crores. The problem is when it's in the after proceedings they invoke later on the same issue of termination. I objected from the question of res immediata. That once this honorable court has held the termination value on merits, then therefore it will be reallocated in separate proceedings. That is my case over there. There, my lords, they have been taking repeated adjournment since last 6 months. Because I have already counted claim over there, those are delayed. And the total null's value of those claims are the claim and counter claim is almost 180 crores. There are last 6 months repeated adjournments on the ground that this appeal is pending and continuation of delay is pending. That's my submission. I have found all the way down. And on the last day, was Tiwari was brilliantly the appellant. That's what now side. Understood.
My lords, we would like to file our reply to the objection that has been filed yesterday. So, my lord, may fix it on.
Serious submission has been made that Mr. Tiwari was the lead counsel in the last date.
Mr. Tiwari is representing the appellants, my lord.
Government, the name of another counsel.
My lord, Mr. SP Sharma is the assisting counsel in this matter, my lord. His presence would be required, my lord, because.
Respect to other. Yes, please repeat again.
My lord, Mr. SP Sharma is the briefing counsel in this matter, and his presence would be required, my lord. He's in bereavement due to the recent demise of his father. That is the ground we're seeking some time for. And some time would also be required to file the reply to the objection.
We grant you 3 days time for that. We'll take it up next week.
My lords, if it can be taken on the 20th of May, my lords, the rituals for the after the would be over till then, my lord. My lords, am I audible, my lords?
Yes.
So far, my objections are concerned. It's a combination of their application notes. We not even consider my objection because they are basically legal arguments. Because now today we see the application for movement law. No explanation also, the only explanation is.
No, that's okay, but it doesn't help us. You see, if you spend 2 minutes time or half an hour doesn't help us.
I understand.
On the ground of bereavement and if the last rights are there, we can't really take up the matter. We'll fix it on 20.
First, can you then first make the back and down because I have the council is dealing with the matter there also. My client wants to be. First, can it be 3rd of June?
3rd of June?
3rd of June.
Is it okay? Applicant counsel.
My lords, 3rd of June.
Okay.
3rd.
Both sides are represented. On behalf of the applicant, a prayer for adjournment is made on the ground that Mr. SP Sharma, the instructing counsel, is in bereavement. And bereavement, next paragraph, the Mr. Your name?
N. Sharma. N. Sharma.
N. Sharma.
My lord. My lords.
N. Sharma makes prayer through video conferencing mode. Next, Mr. A. Garg, learned counsel for the respondent, submits that that a fixed date for taking up the matter be given so that the matter is not adjourned on the next date of listing. Next paragraph. Both sides agree to have the matter for hearing of the matter on 3/6/2026. So it is made clear that matter would not be adjourned on that date. List on 3/6/2026.
For others, some member.
Just a moment. If any pleadings are to be exchanged, the same shall be done within an outer limit of 2 weeks from the date of the order.
I'm deeply obliged, my lords.
Yes.
Or we have effected notice from the floor until the fourth, and to that effect, we have plans on the board and appeal. And to the problems open here, we have effected notice on 27th, and we are awaiting the outcome. But we have in the week of this work. A copy of the scope of
But I think you'll have to file an affidavit to bring it on record.
this, there must be a part of the it's interesting. I believe it's in.
No, you see, we have relaxed our procedures. You can always sign it as true copy and file it. It's a Bar Council of India to be served. Once an affidavit is coming, we can still, if there's no, what you call this, if it is correctly served, we don't have an objection to that. We are taking up scanned copies. We are allowing you to file documents through e-mode.
Just the point section is insisting that it has to be the original hard copy. That's why we want to take the leave of this work.
Okay, we'll grant you leave. File with the true copy. Okay. You're all there? You're appearing for the state, and the Bar Council is represented? No. You're appearing for the Bar Council. Okay. So then it's not required. Your affidavit can be dispensed with. Next week. Okay.
Since the last date for registration is tomorrow.
What registration?
Registration for the exam.
When is the due date?
Tomorrow, the last day for registration is tomorrow, presentation for the examination is on 7th of June. However, you choose the examination center, the registration process tomorrow, that is why if the engineer can consider today or pass the and just see which includes the investigation with regard to the schedule.
No, I think it's been done, but I'm not.
Let's look at this. There's a promotional. What's within on the plot? We must go about the examination center. You see, we are just thinking of the logistics to have an exam which is scheduled on 7th. We don't think it would be appropriate to pass any interim order to have an examination center located within 7 days, even if it is temporary. it takes a lot of effort to have an examination center designated. And I'm experienced with that work because at times the recruitment in the High Court, I have dealt with several recruitment processes. It takes a lot of time to move the authorities to have a center, to have logistics kept in place for the purpose of an examination. There are many things to be done. Not only the venue has to be given, but the payment to the authority of the venues. Let us say a school is engaged. There also a school or college, they have to make payments. The logistics have to be made. Police has to be informed. Then security measures are to be taken. I don't think even if we pass an order, it will be an appropriate way to do it in 7 days' time.
Will the exam.
7 June. Oh, it is 7 June, not 7/5.
Finish the exam, Lordship. Registration process tomorrow. We have a month's time, Lordship, for the examination.
Okay, then next week on the issue of the temporary examination center at Nagaland. And it would be appropriate also. Student traveling from here to another state to give an examination, bar examination. I think it is appropriate that the state must have a center.
Nearest.
It is in overwhelming public interest.
My concern is just that since the registration process tomorrow, if an instruction can be, so would you go to extension of the registration if this was?
No, registration can always go on for this, for the state of Nagaland, we can always have it segregated. You may have, you see, in an examination, you may have a center taken, for example, you want Kolkata, registration is made. But by virtue of orders of the court, we can always direct the authorities to have this roll number segregated for the purpose of having this examination at Nagaland. It will indicate who is order. Please give your names. I forgetful of the names. I'm sorry. Parties. Next para. The learned counsel for the petitioner has submitted that the notice of this writ petition has been served on the Bar Council of India, respondent number 2 by Dasti, and a scanned copy of the acknowledgement has been produced. Full stop. Next para, as Mr. No, for the Bar Council you are appearing. Appearing on your name. Learned counsel appears on behalf of Mr. P. Mahanta, standing counsel for the Bar Council of India, and submits that the notice has been served on the respondent number 2, and he is instructed to appear in the matter. However, he seeks some time to address the court in respect of the issue involved. Full stop. Accordingly, as the learned counsel has entered appearance for respondent number 2, the filing of an affidavit of service of notice is dispensed with. Next para. The learned counsel for the petition has submitted that there are several candidates who intend to appear for the All India Bar Examination from the state of Nagaland And accordingly, by filing this PIL, direction is being sought for against the respondents to have examination centers in the state of Nagaland. First off, he also submits that the last date for submission of applications and for registration of such of the candidates for such examination would close on 5/5/2020. It will be tomorrow, 30, 30/34/2026. Accordingly, it is submitted that if an interim order is not passed, the candidates who would have registered by 30/4/2026 would have to appear at the designated examination centers outside the state of Nagaland. Next paragraph. The court is of the considered opinion that as the examination is scheduled on 7/6/2026, no interim order is called for at this stage today, as the court can still pass an order on a subsequent date so as to direct the Bar Council of India to give options to the candidates of the state of Nagaland to reschedule their examinations at the center within the state of Nagaland. Next paragraph. Accordingly, the respondent number 2 is put to notice that keeping the issue of having examination centers in the state of Nagaland open, prayer for adjournment is allowed to the respondent number 2 to file their affidavit in opposition or to make their submissions in respect of the prayers made in the writ petition. And who is appearing for 3? For respondent number 3 is the Bar Council of Assam. Your notice is out. Your affidavit is not here. Okay. Next paragraph, the learned counsel for the petitioner submitted that in the meanwhile, affidavit of justice service of notice on respondent number 3 has been filed. Instead of the registry shall tag the same on record. You are appearing for? For respondent number 1. Okay, your presence will be recorded. For respondent number 1 and respondent number 4. Next paragraph. We request the learned counsel for the respondent number 2 to send a downloaded copy of this order to the respondent number 2 to put the said respondent to notice of the order. List on 6/5/2026.
For orders, item number 4 and 5.
Yes.
It is fine. The sun will have ordered within for the right. Okay, there are 2025. The villains were allowed to proceed with the examination process. But final result shall not be declared without the leave of this honorable court. Pursuant to the order passed by this honorable court, the selection process has been proceeded And the last stage is the medical examination. That is also done, and the result is repeated. However, in view of the order passed by this Honorable Court, the result could not be declared. And delay in declaring the result respect of violating the consequences in any selection process for it. So the respondents will be allowed to declare their final results, since all the process have been completed.
You see, the results are declared.
No, final result.
No, we are telling you, I am asking you, if the results are declared by virtue of orders of the court, then what would survive in your writ appeal?
That's the survival. Yes.
ठीक है ना? Actually, so stated yesterday that was.
No, I don't know. I can do that. I can clarify.
Listeners have participated in this.
No, this appeal is by the state. You are appealing for the state.
Yes.
Uh, can you take instructions and we can record it that then we'll say in view of the appeal file, this interrogatory application file, as the result, if on declaration result nothing would survive for consideration in this appeal, in the connected appeal. So we close the appeal also then.
Okay.
Reserving right to you, if you are aggrieved, you can still come up.
Okay. Then what if during instead of taking out the IA, if the appeal can be disposed of village on the next. Yes, yeah.
No, you see, state has the urgency. If the state has conducted an examination, it is the interest of the state to have it. Your writ petition was allowed.
Yes.
In terms of allowing of the writ petition, this appeal has been filed.
Yes.
Now they want to be declared, so it is in your favor. Why do you want a hearing?
Which party or what you need to that? They order which was passed. It was in my absence.
It was passed in favor of the respondents. You appear for whom?
I am appearing only recently on behalf of the petitioner.
You are not the petitioner. He is the petitioner, appellant.
No, I was the petitioner.
Response to the petitioner who has appeared in the selection process.
Yes.
And after participating in the selection process, in the midway they have challenged. And then the challenge, the writ petition was allowed. Against that order, the writ petition has been filed by the state. And
How can you be aggrieved? How can you insist on a hearing?
The order was impugn order is in your favor, right?
Yes.
So if the writ becomes infructuous, the order in your favor attains finality.
Yes.
Isn't it?
You are contesting your own order.
So
Then we'll record it that the appellant wants to contest the order. If that do so, then also his appeal is allowed. Once you take a stand that you want to contest, you see, as a holder of the order, you always have a right to challenge any part of the order with which you are aggrieved. So we'll take it that you are challenging a part of that order then.
No, no.
It would amount to cross objection.
If they are allowed to get the result, then in that case, it will be against me.
Why? Please tell us why.
Because the exam has been cancelled by the imperial order. The entire examination process has been cancelled. It was working the court to the
Oh, which process? Which process? Which process?
You can present the Chinese person. Yeah, price process. Price process over the you can still what? I was thinking of my price of the advertisement later done.
Okay, we find strong point in his favor.
Then Lordship let it be heard on 6th.
Sixth,
Yes. And that they are still considering the idea entire let will be disposed.
okay. Okay, both sides are represented. In view of the nature of challenge made in the connected appeal, it is deemed appropriate that this interlocutory application, that instead of taking up the interlocutory application for disposal, the connected appeal being WA 39 of 2025 shall be heard out of turn. This is the matter for hearing on 6/5/2026.
For all, item number 6. For orders, I beg your pardon, for hearing, item number 6.
This one, the unlisted motion, this one, 35, 36.
But this will take some time. In the meantime, we'll take it. Just wait for some time. The unlisted motions matters will take it up. You can take it this.
Unlisted motion, item number 35, WP Criminal 9 of 2026.
The particular hearing is the wife of the detainee. And for this petition, she is seeking to invoke a representation of her dated 23 January 2026. The approval of her dated 02/02/2026 and the confirmation of her dated 14 April 2026. And the primary ground seeking for revocation of the information orders are that there is a gross violation of section 10 of the National Security Act. For section 10 of the National Security Act, the only permit is to refer the matter to the advisory board within 2 weeks on the case of litigation. Or the advisory board or the public government to have referred the matter among the terms of litigation before the advisory board. Letters of 14/02/2026. However,
Okay, we'll issue notice.
um,
You had taken into custody on
29/12/2025. 29/12/2025.
and if we supposing at the end of the proceedings, we allow your writ petition, then you will do the same thing again, this time in a different locality?
No.
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 But what was done was not good. People like this should be kept incarcerated. Okay. heard Mr. A. Sophie, learned counsel for the petitioner, and Miss learned government advocate appearing. Huh?
Public.
Learned appearing for the respondents.
1, 3, 4, 5, and 6.
1, 3,
4, 5,
4, 5, and 6.
Yes.
CGC is not there. None appears on, no CGC is represented for respondent number 2. Next paragraph. By filing this habeas corpus petition on Article 226 of the Constitution of India, the petitioner has assailed the detention order dated 23/1/2026, page
Page number 22.
22, within bracket, page 22, as well as the confirmation order
Page number 41.
dated 14/4/2026, within bracket, page
41.
41. Thereby permitting detention of the petitioner for 3 months with effect from 23/4/2026 till 22/7/2026, subject to further review under the NSA, 1980. Post. The learned counsel for the petitioner has submitted that the detention orders are sought to be quashed owing to the procedural lapses on part of the state respondents in taking timely steps. Next para, issue notice returnable on this is from which place? He's detained at which place? Dimapur. Then okay, 6th. Madam, 15 days we must make an endeavor to dispose it within 2 weeks. Make it 6 on 6/5/2026. Next, requisite extra copies of the writ petition, along with one soft copy of the writ petition, be served on the learned government advocate and to the learned CGC in course of the day. You have to give a scanned copy to her. Next paragraph. The learned CGC and the learned government advocate shall transmit the order of this court to the concerned respondent authorities so as to enable her to obtain instructions on time. Next paragraph, list on 6/5/2026.
On the list of motion, item number 36, WA 15 of 2026.
Selected against the common action of 23rd March 2026 of this. If you have been considered lordship, let it be brief as far as possible. In 1971, the petitioner's father was issued a special permit of about 100 acres of land. And then he was saying that in due course, there has been some encroachment. So the submitted a complaint to the government, that is to the chief secretary. In 1996, the Chief Secretary has issued an order which says that the government right has been alienated in respect of that land by the special permit has already granted the right to the acquisition. But then the government has been disturbing the petitioner, so he approached the honorable court by way of filing a petition where petition was allowed, but with direction to conduct inquiries. And then the report was submitted. Thereafter, the duty commissioner issued the order of eviction, restraining order and eviction. So the petitioner has had an petition. In the final outcome of the petition, the learned civil that has comforted Hydro to that is headed at Hydro. So in view of this order, if the petitioner wants to file a suit, because in view of the conflicting disputes and orders, the best appropriate state course of action would to happen file a civil suit and decide it here. But this honorable court has decided the time already. So at this stage, I would only pray that.
So just. Without prejudice. To this order. We answer for the search of the only take it yes, right? As well as the line to say. Line during the and you will say activities for this, that means license as well. There is no comfort with the right of the vehicles. Position only for the purpose of that. So that becomes a license is then a judgment audience.
Which is that part of the observation of the done a single judge declaring the title? Because we find that it's only an observation of the court. What the court has actually done had gone to the genesis of the 71 order, and it arrives at a finding that that lease license was given to you only for the purpose of agriculture, and therefore light was not transferred. And then it says that in this writ petition, as the vacation orders was not challenged, and the person that Cognac is not also a party, therefore the writ petition was dismissed. So we don't think that any observation made in this order will be contrary to your interest if you file a civil suit.
It comes with page 247.
247. Yes.
I will refer to this paragraph only.
Yes.
Second paragraph, the sentence start with the proceed.
Yes, we have read this.
The proceed definition of total license makes it clear that no interest in the movable property is created by grant of the license. It is only a permissive occupation given to the licensee to use the movable property for a particular purpose. From there, it will be important. A license being a matter purely personal between the ground of the grantee and the same is neither heritable nor transferable. The permit did not confer any ownership or title of the petitioner's father over the land covered by the special permit. In other words, the permit holder is merely a license, not an owner or a tenant. The permit to cultivate gives only a temporary right to use the land. On the other hand, if the special permit was made through an order of allotment, it would have conferred a legal right or interest over the land. However, and mere permission or license like the special permit granted to the petitioner's father was for a special reason, permit to cultivate. It is therefore nothing transferable and nothing heritable as a permit to cultivate is merely a personal license granted to a specific individual and has no created any right, title, or interest in land. This is important. Just as a license ends with the date of the licensee, such a permit would have ended with the date of the petitioner's father. The permit license would automatically lapse and terminate when the holder dies, and legal heirs do not get any vested right unless there is a condition in the permit itself that specifically allows the succession or regularization in favor of legal heirs, or if the district administration government had formally renewed the permit in the petitioner's name or converted the permit into an allotment or lease.
Just we pause for a moment here. In the state of Nagaland, Do you have any Agricultural Tenancy Act or something like that,
No,
which confers upon the person?
we can, in Timapur, it is applicable in full, in full. But in the rest of the state, the spirit of assembly and regulation in 1886 is applicable in the state of Nagaland. So that is why we are using PATA and allotment and all this. These are all inherited from the assembly and regulation. So that is the practice. Now, kindly come to page 72. Because why I'm saying conflicting orders. Government has given the license under the chief secretary what it says in the order. And this is under complaint lodged by the petitioner. And without taking into consideration of this document, the DC has passed the order and this honorable court has also passed an order. So there are two conflicting orders. So it can be decided by the civil court who is the right hand holder of the land. But without taking into consideration of all this, the learned single judge has upheld the cancellation of the special permit without taking into consideration of this statement. So can you come to page 72? I will just read this letter and George will note for this first value of this. 18 July 1996. This is by the Chief Secretary. A representation has been submitted to me by L. Lokman Wongshu, son of Lokman Wongshu. The appellant is there, and the petitioner is the son of this Lokman Wongshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. The special permit for farmland at Desert was given to late Lokman Wongshu. The 10th RCM and the area given to him was property alienated. This is very important. Property alienated. In course of time, encroachment had taken place by the Forest Department, Industry Department, and also by private individuals. So permits given by administration at different times.
Just a moment, Mr. Zamir. Please come to page 59. This is your special permit
Yes,
for farmland at Tejit. Correct?
yes.
Now, this clearly says that it's a permit. You'll have to show us that the permit is otherwise inheritable.
Permit. This is a special permit in the Chief Secretary's letter which you will find. The reason for granting the special permit is because of his contribution for the welfare of the state. It was not just really given. He was father of the appellant was the RCM, Regional Council members. Immediately after the state vote, the powers have been given to the Regional Council members to represent the government also in various developmental activities and they were the agents of the government. So in the cooperation of his services, he was given the special permit. Otherwise,
To cultivate. To cultivate.
yes, I mean cultivate, I mean not cultivate. But
No, no, no.
given-
The change of user is not permissible.
What is meant by alienation?
No, because fundamentally you'll have to show us that permit is otherwise inheritable. Permit is normally not inheritable.
There may be some technical flaws for not transferring, but then.
No, you apply for your what do you call that this court has not barred. If it's a permit and you think it's inheritable, then you have to apply for that. The order, we don't find anything wrong in the appellate order. The petition order. At best we can do is that if you want to pursue any remedy, then this order shall not prejudice you. At best.
High Court has already conferred the hand.
No. Nowhere it is given that declaration.
So to approach the civil court also, this.
Civil court is it will totally bad. Because to enforce a right of permit, a civil suit would not be entertainable. It's not a dispute with regard to title. You are claiming permit as a matter of right, which the civil court will not have power. I can't direct this state by civil suit to give me allotment of land at a place A.
But at least Deputy Commissioner as well as this Honorable Court Learning University ought to have considered the order of the Chief Secretary. And this has not been taken into consideration by both TC and the Learning University. My right flows from here, not from the special permit. On the basis of this, I'm claiming. Not on the basis of the special permit, because this has already superseded the special permit. And that aspect of the matter has not been taken care of by the DC as well as by the.
Mr. Samir, doesn't help you. The reason is very simple. Please come to this page 72. This is the one you are referring to. Right?
Yes.
Now you have to show us the jurisdiction of the Chief Secretary to take up any such matter. Let me give a horrible example. As you know, I'm not entitled to a land in the state of Nagaland. Now I make an application before the Deputy Commissioner, please allot me a land. He refuses. I go to the Chief Secretary and tell him that, well, I need a land, please allot it to me. And he says, I take up the matter and I find him to be entitled to. He has rendered a lot of service for the state of Nagaland and therefore we give a direction. It's a horrible example. But you see, he must be assigned with an authority to take up the matter in appeal or in revision. He can't usurp the power just because he's the Chief Secretary. Each and every order he can't.
But Chief Secretary has the power to defend the action of the government. He is the head of the state.
No.
Head of the government. Therefore.
Then there's no requirement of any other department. If you can take up everything. I'm sorry, I'm not with you.
This was in recognition of the services rendered by the state administration of the state.
You apply this and you apply before the authorities for the permit, for granting of permit in your name. Whatever, because the permit has to have a source of power. Either it has to be saved under Article 272, the power can be either saved, or it will have a source of power through some legislation or a notification, which is law for the timing in force under Article 13.
But my grievance is that at least the order passed by the Chief Secretary should be ordered. And the order of the Chief Secretary is that you conduct an inquiry whether it is encroachment or not. But they have gone beyond that.
I don't know, I had limited time to read this order of the Learned Secretary. I don't find anything. Clear.
Elevation কৰিছে ৰুব পৰা পাৱাৰ আছে লাইসেন্স
Achha, just give me the act, Assam, Nagaland land. No, land. There's a policy, land policy. What is that? You have a land policy.
Yes. As far as the matters concerning accusation and accusation. Yes.
Nagaland Requisition and Acquisition Act, but that.
No, that will not apply here.
This case.
Not apply. You have a land policy.
There is a combination issued by the Land Revenue Department. Except that.
No, not this.
That will.
Not this. This is land policy.
That is not regulated to the government agencies.
Just find out.
Lordship, even on the West, my God, if I may be allowed to make a short submission here. Your Lordship is correct, because here, Your Lordship, the learned single judge has given the interpretations of permit.
No, not that. We wanted to look into the land policy because somehow I have some memory about land policy existing. It may be by way of comparison of notification or something, but I remember having seen that. You see, if there is a policy of land allotment, because somebody has given this land at page what do you call, allotment was made, right? You're only at 29 March 71, page 59. So is there a source of power? We wanted to know that.
I think Your Lordship, in this matter, as far as this page 59 is concerned, Your Lordship could clearly see at the bottom part that this is not an allotment, Your Lordship. If I may be allowed to read just that part, Your Lordship.
Yes.
Six lines from the bottom, my Lord,
Yes.
starting from this dead tree.
From the dead tree.
Yes, from this dead tree, a line will continue straight for a few yards, then turn southwest and join now the June. Following the area already June this year, a line should join the Cheat River near the pool called Chizet. Your Lordship, now this is important. Besides this area, he is also allowed to continue petty cultivation at the confluence of the Tiji and as has been shown in the map. Besides these two areas, he shall regain all the areas he has put under cultivations immediately. So it is just for the purpose of cultivation, Your Lordship. Therefore, it clearly says, besides this area, he is allowed to continue cultivation. So this permit is only meant for cultivation. It is not an allotment in any other way, sir. And it cannot be translated that way, as my Lord has correctly pointed out.
Lordships,
You look at page 61.
Yes.
today the situation is quite different. We are governed by different complete sets of law and rules and regulations. Imagine about 1971, that is very few years after the state vote. So nothing was streamlined properly. So I see something, one executive engineer was having the power of chief secretary also. He will just see, inspect and order will be issued. And that will be the order of the law. Like that. It has been continued for few years.
No, because you see, if this is a contour map,
Yes.
page 61,
Yes.
then entire 100-acre land
Yes.
is not a cultivatable land. It can't be cultivated.
Your Lordship, because this map arises from this special permit dated 29th of March 2071.
No, that's fair. But
Yes, so this map pertains to the area where the petitioner's deceased father was allowed to cultivate, my Lord.
But this is not a cultivatable area. Entire area is not a cultivatable area because if it's a contour map,
Yeah.
this is a drawing taken out of a contour map. And in contour map, if there are these circles are there, that means this is either a hilly terrain or it will be a water body.
Your Lordship, it was a thick jungle at that point of time. And the thick jungle was actually given to the government by a village called Jaboga village. That was the land donated to the government by the Jaboga village for the establishment of PG Township, Your Lordship. And from that area Your Lordship, the Jaboga village donated to the government comprises of 1,200 acres of land.
I'll tell you something. My examples are horrible. Please excuse me for that. Now, you see, you gift me this pen.
Yes.
Today morning when I come sit here, you are gifting me this pen.
Yes.
And no conditions are attached that this is a pen which can only be used for the purpose of writing.
Correct.
So what I do is that I take out this cap.
Yeah.
I have to, I substitute it for the cap I lost in my yesterday's pen.
Yeah.
I use this. There's a refill. I have another pen which does not have a refill. So I open up the refill and I put it there.
Yeah.
Can you say it is illegal?
No, Lordship. Here, the issue is, Your Lordship.
No, once you donate land,
Yeah.
you give title to someone. And therefore it is his authority to do whatever he wants to do with that.
See, that's the point, Your Lordship. So therefore, Your Lordship, that the donation was done by the Jaboga village to the government. Here, the government has not donated the land to the petitioner deceased father. The government has allowed the petitioner, this is further to cultivate.
But that's the problem we are finding.
Yeah.
Page 61 does not show that the area is cultivable. Therefore, what is the intention of giving that land?
Because so much, the point, what happened is 1971. For establishment of the G town, the area that was donated to the government was comprised of thick forest. And that is the reason why just to clear off the jungles, this kind of permission was given so that they can cultivate and clear off the jungles. That is also there, Your Lordship, in the report. It is there in the report.
But that report is not preceding 71. The report which you are referring to
Yes.
is pursuant to an inquiry ordered. Special inquiry was ordered in 2014,
Correct.
31/10/2014. So after that, this report came.
Yes.
So what transpired in 1971, we still don't know.
Your Lordship, again, this survey map was done.
You see, we must, if we have to know the genesis of 71 document, we must know the environment which was prevailing in 1971, whether there was a tree, there was no tree, there was hill, or there was.
No, Your Lordship, this survey map was conducted. Another big survey map was conducted after 1971.
That was
Show us-
Secretary's order.
Show us this inquiry report.
Secretary stated there is a review, on the basis of a complaint, it was passed. So the complaint was placed in enforcement by the government department. So
84.
this examine.
84.
84.
The special inquiry was confined to enforcement.
Okay.
Your Lordship, I will find
we
a
have
page.
done so many things, so many new things, so many new developments. They are capable of doing that, they are done, everything is with them.
Page 86, Your Lordship will find a second paragraph on close examination. Here, if you see again, Your Lordship, another map, another survey was conducted along with the petition. And he has admitted, yes, he has no knowledge.
Chief Secretary has said that
We don't find this impressive. This is a survey done in 2014,
Yes, yes.
correct? In 2014, only what you had to do was to get the Google map of different timeline and have it superimposed and then find out what was the position then. So
At the end, I just wanted to take my lordship to one more order, a paragraph of the order of the Department and order lordship. If my lord can kindly come to the last.
where's the High Court order?
Yeah.
Yes, 2012, that 5/8/2014. Where is that?
5/8/2014, your lordship.
High Court order.
At page 143, no, 204/2012. This is the basic.
Yes, just a-
143, page 143.
যিকোনো মেটাৰত য'ত ৰাইট টাইটেল আহে কথাটো মেবি ৰিপিটিশ্যন মেবি এনি পচিবল মই 26 ফুল 10 to 1 ইনকুৱাৰী বহুত টাইম অৰ্ডাৰ দি কোড বিকম সাৰ্ভিস সো ওয়ান্স ইট ইজ এভিডেন্স যাতে হাইকোর্টে প্রুভ কৰিব দিলে এভিডেন্স আমি এটা মানি দিলি মই কৰি দিলি আমাকে প্রিটি কৰিব তেতিয়া আমি বেছি কৰিব নিদিওঁ প্ৰব্লেম নাই আমি ব্যাংক সামনে কি আছে আপনি ডাইরেক্ট কৰিব দিলে নেক্সট মই আৰু চিফিং এক হৈ আছে মই এটা বনাই দিলোঁ সেইটো বাইণ্ড হৈ গ'লে ক'ত বাইণ্ড হৈ গ'ল তেতিয়া ন এইটো চুপ আছে
can we come to page 18 of it? This is an order.
No, just the High Court order we wanted to see. Which page is that?
143.
143.
Yeah.
Mhm.
But the prayer not one for 50.
Yes, we have read that.
And this period of position, I feel inclined to allow here the reference of chief secretaries, letter state. So as I have done repeatedly submitting before the number for the letter of chief secretary is confined to a complaint filed by the petitioner. And that was to inquire about the encroachment. Chief secretary is saying that some departments are encroaching the land. So inquiry, special inquiry is to be conducted whether it is encroachment or not. But in due course of that has been misinterpreted, that at least inquiry should be done. But the letter, as mentioned in this General Court's order by 2014, passed in 2004, is as a reference to the chief secretary's letter of
It is.
1996.
There is. Now, where is the order cancelling the special permit? Where is that?
Legislation of 158. Because we want the more land, so we have this.
No, Your Lordship. In fact, the petitioner has sold a considerable areas of land to the private respondents at an exorbitant rate. We have already mentioned that in our Philippine version with the report. The petitioner has never declined or denied that particular survey. Lordship. Without having the allotment order, without the land being in his name, Your Lordship. Even now, Your Lordship.
You remind me of something. I'm good storyteller, so you have to listen to. You see, in course of one matter which I was earlier as a lawyer, I was handling, the parties in dispute took me to out of Assam, and we saw that land which was the subject matter, and close to the land is another plot of land barricaded and I suddenly asked that why this land, so large part of land has been barricaded, and it appears to be barren. Not even a single grass is there. So, is this land having minerals or something? I said, no, it's an agricultural land. And it is one of the largest producing, what you call, agriculture area in this entire district. I said, I'm surprised it doesn't show a bit of even a grass, and you say it's highest. Yes, on papers. So the land belongs to there is an agriculture income rising out of that, and that funds for everything. Similar story. If you're once given a permit and you don't have control, people will do what they want to do.
Correct. That's correct.
Stage. In view of the single judge order, the government may issue eviction order like that. So for a time being, the status quo may be maintained with regard to the land and the payment will be heard. And then the three with petitions also involved in this. Among this.
For different lands,
No, same,
same land.
but different course of action arising out of the same name.
But this is not an order of cancellation of permit. This page 153 is not an order of cancellation of permit.
158.
158, oh, sorry, I was reading 153.
Type copy dots to find at 159.
Okay.
Come to one small end, so this is cancel that out. This data investment, no. For the subsequent actions.
The issue is, what is the nature of that permit which was given to them? Whether it is by way of a license
Yes,
or whether it is a permanent allotment.
yes,
That's the
issue.
single learned single judge has held that it does not, it is not a permanent law.
No, Your Worship, another thing is that can a permit be inherited? Because the permit was granted to his father, to the petitioner's father, not to him.
No, that'll again depend on if the name is permit, but if it is a permanent alienation, allotment of land,
Yes, if there is allotment of, correct,
then
correct,
it
correct.
would,
Yes,
otherwise not.
no. So there has to be an allotment, that is the entire contention of the state respondent in this application.
Okay, we'll deliberate and pass orders. We'll fix it for passing appropriate on 6th.
Before I conclude, allow me to take my lordship to page 214. It's just this movement and not submission.
249.
214, kindly, Your Lordship, kindly.
Mr. Angami is very persuasive.
I am deeply aware the lordship for patient, patient with me.
220.
No, 249.
249.
Second last.
Acha.
Yes.
Yes.
I'll just refer to paragraph 28 to 9 and 30. May I read this, Your Lordship, while you are moving? In the judgment order 5 from 14 parts in the WPC 204, paragraph 1 to 5 are only the narrations of the pleadings made by the petitioner in the writ petition, and it is not the finding of the court. The direction is contained only in paragraph 6 of the judgment and order, which have been complied with by the state respondent. In the facts and circumstances as discussed above, this court finds the petitioner has to invoke the jurisdictions of this court under the Constitution of India and the petitions being devoid of merit is dismissed. Paragraph 29, Your Lordship. In the WPC 58 of 2017, the petitioner has assailed an alleged illegal land permit that is 15/5/2011, which is not annexed in the writ petition. The petitioner has also assailed a vacation order that is 13/4/2017 issued to one Mr. Wundrung Konak. As the agreed person, Mr. Wundrung Konak is not before this court in the WPC 58 of 2017, and the impugned land permit that is 15/5/2011 is not annexed in the petition 15. The WPC 58 of 2017 is dismissed as not untenable. Paragraph 30, my lord. In respect of the WPC 2070 of 2016, the petitioner has prayed for quashing and setting aside the impugned restraining order issued to 7 persons dated 15/1/2015 and 12/10/2016 by impugned order dated 20/10/2016. However, in the WPC 2070 of 2016 also, the 7 appeal persons are not before this court. Therefore, the WPC 2070 of 2016 is also dismissed as not written. So the ground for dismissal, Your Lordship, as far as disputed petitions, is on the ground of compatibility. That I just wanted to point out, Your Lordship.
Where is the rate petition of 58? 50, rate petition 58. Is it at page 29?
Your Lordship, they have filed 3 separate rate petitions. Rate petition 58, according to what they have given me, is rate appeal 16.
Okay. Separate appeals are filed. Okay.
Since South Korea High Court rules,
No, we understand. That's why 58, I did not notice it earlier here. That's why I'm asking. This is 58. Okay.
Yes. And 207, Your Lordship, the WPC 207 is the WPC, the rate appeal 17.
Okay.
those cases, those other 2 cases are righteous. That Lieutenant even was said,
Okay.
may not be that vital.
Okay. You see, heard Mr. C.T. Zamit and the senior counsel assisted by Mr. I. N. Chen, learned counsel for the appellant, on admission of this appeal. Sorry, as well as Mr. N. Angami, learned
Senior government.
senior government advocate for the all the respondents.
So, it's only one form.
1, 2, 4.
Yes.
For admission hearing, list on 6/5/2024 for delivery of orders.
Many times, status form will be changed with that.
We'll take note of that. We are not passing any order right now.
Then if there is some problem, then present to the report order, it will break on the issue.
Okay, you see, if the next para, on the prayer made by learned senior counsel for the appellant, it is provided that in the event any steps adverse to his interest, to the interest of the appellant is taken, he is at liberty to move this court before the next date of listing. Just make a mention.
In the meantime.
We'll take note of that. And you just tell the authorities, they should not do it in a hurry.
So there's nothing in the order directing us.
But still tell people who are interested, they will not do it.
And video.
I can inform my client that the buses were repeated and then they have already conducted the measurement and all this.
Whatever, please tell the deputy commissioner. Till 6th, no, nothing adverse be done.
Your Lordship, as far as the delays are concerned, Your Lordship, I have not received anything that there is such.
Just communicate.
Yes.
Just communicate the view of the court.
State Lordship, no,
I will listen.
taken pursuant to the justice. Otherwise, I'll have no protection.
The 6th. No. Don't say that last part. You say the learned senior counsel for the petitioner prays for interim protection till the next date of listing. Next para, accordingly, it is provided that now the full stop, the prayer is opposed by the learned government senior government advocate. Next para. Be that as it may, as the matter is fixed for orders on 6/5/2026, the state respondent shall not disturb the position of the petitioner till then.
On that.
Mr. Khalid, though we took up other matters, but I think we'll have very short time
Citation. We just seems like to respect and Legend even suggesting the order that it simply to 2023 it was an special court postponed. The individual sentence under section 54 IPC 377 IPC 506 IPC and section 44 postpones and section 7 and section 8 above. Here in this case, the PW1 files the affair with the village category. And PW2 is the only eyewitness. PW2 informs the unknown person PW3. Then PW3 goes to PW1 upon discussion of the village council find the affair. We have served notice upon them, both Dusty and all these things. They have not appeared before this planet for the lordship. Lordship may kindly come to this statement of the PW one, your worship. I witness is number 36, your worship. Paper with your worship. Number 36 of the paper with your worship.
Yes,
Shall I register now?
34.
There's no
Just 36. Just out of the video conferencing. And live streaming should be switched off. Huh? Muted. Live streaming stopped, no? Okay. Yes.
I was feeling it goes to then I had it sides streaming, so I came out from the masjid and went towards the house. From where the noise is coming, when I reached the place and where the voice was coming, I saw a door closed. Since the house was press house, and there were gaps, I peeped from the gaps of the house and saw the idiot eating saliva on the side. So this whole is he has seen all this thing, the only eyewitness. Then after seeing all these things, he keeps silence for 3 days. That reason has not been explained. Then this person goes to PW2. Sorry, PW3, who is an unknown person, he has all these things. Then they went to the village station. After 15 days, that has not been delayed. And during this course of 15 days, the child behavior was totally normal. Her mother had not divorced before the court. She was not before the court, but her behavior was totally normal.